All right.
May 14, 2013, Suzanne Simpson shot her husband in bed, and then the next day went into a car, picked up her 2 children, ran into a tree, and killed both of them. She pled guilty by insanity. Today, hi, my name is Meghana COF, and today I'm going to explain to you why guilty by insanity is not a fair verdict for anybody involved. Doing that, I'm going to explain why a person should not plead that, because it's unfair treatment once you get that kind of verdict. The outcomes are horrible, and the state of mind of the individual that has to go through that once incarcerated is not good. The insanity defense in general, the point of it is to is the cognitive prong or a volatile prong must be included in the defense. So basically the lawyer has to prove that they don't know if a person, when they're doing the act, is right or wrong. According to the Louisiana Law Review, this invokes less than 1% of any criminal cases when it's used, and it's only 25% successful. So the insanity defense is not something that a lot of people use because it's hard to actually prove. So the guilty by mental ill laws are deemed unfair by most of the propositions that are held in the states. These laws are said to be held no different from if they're guilty or not. So according to legal resources, by Law Info, the likelihood of someone actually getting that plea is very, very small. And if they get the actual verdict, the actual guilty verdict is, the actual guilty by insanity is so negated where they actually get put in jail and no treatment at all. They get no treatment after they get put in jail. Once they get put in jail, they are confined to a small room, and they're not given any psychiatric help, and so no time for rehabilitation, and actual time to, realize that what they did was wrong, or there's no difference between good and bad. They're kind of put into this, box, and they go even more insane. When given this verdict, when it goes to court, it confuses the jurors. So when you plead the insanity, there are 2 actual things you can plead. You can either plead not guilty by mental illness or guilty by mental illness. If you plead guilty by mental illness, as I stated earlier, then you basically go to jail and there's nothing that changes. If you get acquitted and you get not guilty by mental illness, then you are assigned to treatment, and you get treatment for anything that you would have done. So you get to see a psychiatrist, you get help, and you get rehabilitated, and the potential of actually coming back into society. What that means in general for Suzanne Simpson was when she pled guilty by insanity and she was insane, she had a psychiatrist and she got treated for bipolar disorder. When the psychiatrist evaluated her after that, he deemed her insane, but the problem with this was once it went to court and once the jurors decided that she was actually insane, she went to jail. And 4 years later, she literally sits in a box and nothing different there's no change. If she had actually gotten the help, who knows where she could have been today. Whether or not she would have come back into society is different, but her quality of life would have been better because she attained that kind of help. In Jones versus the US, they found it unconstitutional for states to confine insanity defendants in a mental health facility for a longer period of time than if they went to jail. So basically, in this case, if Suzanne had gotten into the mental health facility, then she would have stayed there for as long as she would have been in jail. So this would have helped her get rehabilitated, get back into people where she could interact and not be such a threat to society. So this could have actually helped her, but instead she ended up in jail, and that hurt her. Those that are given the GVMI verdict don't receive any treatment at all. Like I stated, Suzanne Simpson did not receive any treatment. 4 years later, she's still sitting in this box, and there's absolutely no treatment for her. So for this reason, I think the guilty but mentally ill laws that are in every single state, or that are starting to go to every single state, should be completely eradicated. Thank you.
All right. Well, I like the way that you start with the example. I think that's a good idea to kind of set up a context for us to understand what it is you're talking about. But when you get to the proposition, it's problematic like the last one. It is a claim of value, not a claim of fact. That if you could rephrase it in a way that suggests kind of what you're talking about, that there is a harm that occurs because people take a guilty but mentally ill plea, that some harm occurs because of that, that would be a claim of fact, and that would be the way to go with this argument. At the end of the speech, you actually kind of shy away from the value claim, though, and switch to a policy argument, which is that we should eliminate or eradicate this particular plea. So it goes from being a claim of value to a claim of policy. When it's supposed to be a claim of fact, that's problematic. There's no preview of what the supporting structure is going to be. You kind of dive right in and use the case as an example of some of the things that can happen in the process. I'm not exactly sure why this is unfair, except that you think that this woman is being in a box is a bad thing, and I don't know that the family of her husband who is dead, her children who were, related to his family also, that they feel that this is an unfair thing. They might very well think that she should fry for what happened, much less sit in a box. I imagine that there is probably plenty of anger and irritation that they've lost members of their family, and it's crushing to them. And the society as a whole probably views these behaviors as outrageous as well. The argument has to be why this punishment is inadequate to satisfy either the needs of justice or to be beneficial to the accused. And all of your argument focuses on what's beneficial to the accused, and very little of it has anything to do with how society should be affected by this. It's also problematic. We said that you want to make sure that when you talk about an issue that you explain why it is we need to talk about this. You kind of diminish the importance of this argument. You say it's used in less than 1% of cases, and it's only effective in 25% of those. So it sounds like it's a relatively infrequent thing that we're talking about here. So why is it that we need to worry about this? It applies to a small group of people who have committed a crime that has been acknowledged, whether they plead guilty or whether they plead innocent by insanity or mental impairment. They're acknowledging that they are responsible for the crime or in some way caused the crime to occur. I think there are other arguments to be made here. You really need a structure for the arguments that you've got. You're kind of wandering around with some general impressions about what you think is fair or unfair. You keep coming back to this image of a woman in the box as if that is an argument that suggests that a problem exists. We got a dangerous woman in a box. That's better than having her as a dangerous woman on wheels or a dangerous woman getting married. So that's kind of the thing that's what we have to contrast it to. What alternatives are there? You mentioned, well, they don't get any treatment, but then you tell us that in some cases when they plead the other direction, they do get treatment. Well, if they get treatment in one and they don't get treatment in the other, why would any lawyer ever plead their client guilty by insanity?
It's not the lawyer that pleads it.
Well, see, this is... What's that?
It's the verdict. So the jury and the judge.
It's the sentencing.
It's sentencing. It's the
Well, wait, why does that even come up as a sentence?
That is a sentence, guilty.
No, why does it come... First there had to be a trial, right?
Yeah.
Okay. And they have to be found guilty, right?
Right.
Okay.
No, but like they either...
Wait, what do you mean no but?
They're found guilty by insanity or by insane.
They enter the plea before they don't have a trial.
What's the plea that they enter?
Guilty by insanity or not guilty by insanity.
Okay, and that's what I just said.
Well, even if she did go in not guilty by insanity, but they gave her guilty.
Okay, that's a different issue. Why would any attorney allow their client to plead the one that doesn't get them any treatment? That's what I don't understand. And you say, I mean, I can tell that you were looking at me like, he's an idiot, he doesn't know what I'm talking about. And that's, you're right, because I don't know what you're talking about. I don't understand. Somebody gets accused of the crime, they either plead or they strike some deal, or they are referred, or there's a process that they go through. I have no idea what the process is. That's the problem that I think is going on here. We don't know what the process is, and therefore we don't know what's wrong with the process. You're giving us the outcome, and what you want to be talking about is how the process is problematic. That's the thing that I have the problem with here. All right, I mean, I understand what the sentence is. That I understand. That makes perfect sense. What I don't understand is how do they get this sentence if there are alternatives, and if there aren't alternatives, that's what you need to explain, that they don't get the alternative. That's where I think we're missing the point on this. All right, you had some good citations early on. You had the law review that you cited, and then there was another legal resource that you cited. There was a psychiatrist that was evaluating the woman that in the particular example, and then you had the court case that you cited, which I thought those were pretty good, but the application to the issue that you're talking about what the consequence to the convicted person is, that's the stuff that you need more evidence on. All right, thank you.